The rule of law means, among many other things, that nobody is above the law, not even when you're afraid you might cough. The Oxford Dictionary defines the rule of law in part as the authority and influence of law in society, especially when viewed as a constraint on individual and institutional behavior. Nobody anywhere dared to interpret this as having any exceptions in case of an epidemic, be it an epidemic of hypochondria or other forms. A situation, or indeed an entire society, where the mere opinions of those who pay absolutely no price for being wrong are being taken into consideration to implement illiberal measures, that ceases to be a rule of law and quickly devolves into the rule of men. As a particularity of this, we've all witnessed temporary applications of this during the panic regarding the Wuhan coronavirus, where many state, local and national authorities overnight became what many have correctly termed sanitary dictatorships, in which the marginal opinion of some white coat became law just because, and under ludicrous justifications of precaution, a term that is anything but a legal term. And under such lunacy, basic civil rights have been suspended, overridden, or even actively fought against, initially with very little opposition. Now, some of that is due to inertia, both civil and system inertia or systematic inertia. Very few people in the current generations are accustomed to fight tooth and nail for their basic rights, and the courts seem to represent a system in and of themselves, thus they are as well subjected to inertia. But another reason for the low levels of opposition is because very few people are accustomed to using the courts, in part because most people believe the courts are for criminals and highly experienced lawyers, yet that's not exactly the case. And the role of courts in flattening COVID insanity keeps on being undervalued or downplayed, oftentimes because of misinformation about what courts can do, but sometimes intentionally, especially by those who know for sure that they're wrong and wouldn't like to have to explain themselves in a court of law. Because if they had to do that, then they'd have to either commit perjury or flat out admit that their guidelines are downright false. And you wouldn't want that on the public record, do you? I mean, gotta keep those plebs scared of the coof, man. Let's explore. Hello everyone and welcome to the Freedom Alternative. Alright, so let's discuss some law, or more specifically, lawfare. Now, the term lawfare is still kinda contentious because, well, good luck finding lawyers and activists agreeing on something. But even so, the term lawfare applies to the topic we're about to discuss, namely to use the courts to flatten unreasonable, illiberal, useless, immoral, and illegal measures implemented under the excuse of the Wuhan coronavirus. The most spectacular and, as it turns out, quite far-reaching episode of using the courts against the Wuhan flu measures is the case of 4 German tourists who've been held in quarantine in Portugal because an RT-PCR test came out positive on one of them. They sued the local government and argued that none of them was actually ill and that the quarantine amounts to unlawful arrest. And after multiple litigation on November the 11th, 2020, the Lisbon Court of Appeal agreed. Oh, make no mistake, this was a final decision. No further appeals allowed. Of course, panicards of all stripes went berserk and, I'm sure you are shocked to learn this, tried to destroy the judge's career by filing multiple complaints against them with the Conselho Superior da Magistratura, or the Superior Council of the Judiciary. The CSM, however, backed down from disciplining the judges. The activists will claim that it's because of the protests, but while the protests have likely played a role, The reason is more in line with the idea of separation of powers. After all, if the judiciary cannot rule against the government and the official narrative, then what's the point of having a judiciary in the first place? If the government thinks the decision is wrong, then the government is free to correct the law and or even launch a separate lawsuit, which the government of Portugal did not. Why? Because everyone knows the judges were entirely correct. So, first of all, let me tell you the short version of the story in Portugal, the legal reasoning, and then we shall look at what effects this case has had globally. Some of the things you've seen lately in the discussion about the pandemic were wrongly attributed to Robinette Biden's inauguration. Yes, there was a political reasoning, it just had nothing to do with Robinette, because, believe it or not everything revolves around Washington, but it had a lot to do with the multiple lawsuits that the World Health Organization is already involved in Europe. So, the shortest version of the story is this. The Açores is an archipelago belonging to Portugal. It's one of the two autonomous regions of Portugal, or should I say Portugal, and the other autonomous region being Madeira. 4 German tourists decided to go to Açores. At the airport, some random schmuck from the health authority, that is to say a bureaucrat, decided to retrieve a sample from them on the excuse that the 4 people are to be tested for the presence of SARS-CoV-2. This little fluffy guy, that is. A few hours later, allegedly the results arrived and one of the 4 people allegedly tested positive for the Wuhan coronavirus. As a result, the local health authority ordered all 4 of them to house arrest for 2 weeks. Administrações Regionais de Saúde, or the ARS, simply took it upon themselves to be judge, jury and executioner on the whole issue, as if it were an undeniable fact that A. one of the 4 people was indeed ill with the Chinese virus, B. that person was a danger to others, C. that the RT-PCR test represented definitive evidence on this version of events, and D. that 14 days of arrest is necessary, reasonable and proportionate. The German tourists, however, decided not to be lemmings in front of corrupted and bribed bureaucrats and sued the ARS and took the whole matter all the way up to the appeals court. First, they filed a writ of habeas corpus, that is to say, they asked the court to grant their immediate release as there is reasonable doubt on the measure itself, and then they won. Then they litigated until they proved all 4 points of the ARS to be wrong. The ARS continued to appeal and the matter went to the appeals court of Lisbon, where they also won. The ruling is devastating both to the government of Portugal and to the official COVID-19 narrative. And I call it a narrative because almost nothing of what the media and governments claim about this disease has anything whatsoever to do with science. With scientism, yes, but definitely not science. So that's the shortest version of the story. Now let's look into the legal reasoning. Alright, so the full 34-page ruling will be available for you in the low bar, and of course I won't go into all of it. But if you plan to use this in your country, then of course make sure you get a Portuguese speaker to translate it for you. Don't trust my translation. Those of you living under civil law, that is to say most of the planet except English-speaking countries, China, North Korea and a few low-tier African dictatorships, but everyone else should absolutely try to use this in their courts, because it works. We at Freedom Alternative Network have already filed portions of this in the courts of 2 countries already. One of the filings was already admitted and we're waiting for the first day in court. I'm mentioning this just to exemplify that the reasoning is quite far from frivolous. If it were, we would have been dismissed outright and laughed out of the courtroom by now. So, in order to understand legal reasoning, allow me to introduce you to 4 concepts useful in understanding this case. 1. In dubio pro reo. 2. All that is not explicitly regulated, it does not exist. 3. All that is not done duly in accordance with procedure is ipso facto illegal or disqualified. 4. Unless explicitly in a state of warfare or emergency duly proclaimed in accordance with constitutional procedure, the rights of the individual always, without exception or doubt, supersede the opinions of experts regardless of the field under discussion, up to and including laws passed by the Parliament in the case of constitutional courts and courts of appeal. 5. There is such thing as a hierarchy of norms. Constitution first, then laws by the Parliament, then everything else, starting with government orders and continuing downwards. Alright, now let's explain each of them. Now, sorry for going a bit longer, but if I don't explain these things, then the legal reasoning makes absolutely no sense for almost anyone. So, first of all, in dubio pro reo, which in Latin means when in doubt for the accused. This principle is the short version of an old Roman law principle, first written down about 2,500 years ago as favorabiliores rei potius quam actores habentur, which in English it would mean the condition of the defendant is to be favored over that of the plaintiff, or something to that effect. This older principle evolved into two versions. Almost everyone watching this probably heard of things like reasonable doubt and the so-called rule of lenity, or the rule of strict construction. Reasonable doubt is the English common law version of in dubio pro reo, and it applies to this day in England and all countries with a legal system derived from English common law. In civil law, or Roman law, which is the basis for the legal system in continental Europe, including Portugal, the other version applies, which is called exactly like this: in dubio pro reo. The difference between in dubio pro reo and reasonable doubt is that the former applies to everything, including legislation, science, facts, expert opinion, and so on and so forth. Whereas in English common law, there are different categories of law and principles to invoke when one wishes to raise doubt or question expert opinion or legislation. Under in dubio pro reo, justices are compelled to rule in favor of the defendant both if the evidence is doubtful and if the law itself is doubtful or contradictory, and in the case we're discussing here, both were true. Principle 2. All that is not explicitly regulated, it does not exist. This one is specific to civil law and constitutes a fundamental difference between Roman/civil law and English common law. In English common law, if something is not regulated, then it is not just permitted, but also usable in court and liable. In civil law, however, if something is not explicitly regulated, then it is only permitted, but not usable in court. In the eyes of the law, if something is not regulated, then it does not exist. It is not presumed evil, but it is also not presumed to be true or good. This is important because RT-PCR tests legally don't exist in many countries of Europe, which is why the legal reasoning in the Portuguese case can and should be used in other countries. See where I'm getting at? Principle number 3. All that is not done duly in accordance with procedure is ipso facto illegal or disqualified. Now, some version of this principle exists in the American system as well, which is based on English common law, but is not English common law anymore. However, traditionally, in English common law, evidence can be admitted even if there is no procedure. This is absolutely not the case in civil law. Under civil law, if a piece of evidence is gathered without strict following of the laid out procedure, then that piece of evidence is thrown out regardless of its validity and legally declared non-existent and inadmissible. If the case is in front of an appellate court, such as the Lisbon Court of Appeal or a cassation court, and in other words, not just a specific piece of evidence in a specific trial gets thrown out, but all other evidence gathered in a similarly non-procedural fashion in different trials can also be thrown out on identical procedural arguments. This was used in the Portuguese case as the RT-PCR test was neither retrieved in the presence of a medical doctor as required by procedure, nor interpreted by a medical doctor. In other words, declaring the German tourists ill of the coup is ipso facto not true because it was done without following the procedure. If you don't follow the procedure, you are a liar in the eyes of the law. Welcome to civil law. Principle 4. Unless explicitly in a state of warfare or emergency duly proclaimed in accordance with constitutional procedure, the rights of the individual always, without exception or doubt, supersede the opinions of experts regardless of the field under discussion. This one is pretty self-explanatory, really. Basically, unless there is an emergency duly declared as per constitutional procedure, which usually involves a limited amount of time, a supermajority in the parliament, and a clear and present danger, in all cases, the right of the people are to be judged as more important. This principle does not mean that during the state of emergency or state of war, the rights of the people don't matter. It does mean, however, that during a state of emergency, the rights of the individual are to be judged at least equally with the prerogatives of the state, whereas in all other situations, the rights of the individual are to be judged as inherently superior to the prerogatives of the state. I hope that makes sense. Well, if it's still unclear, it will become clear as I explain the case itself. And finally, principle number 5, the normative hierarchy or the hierarchy of regulatory norms. This principle is very simple. Not all regulations are created equal, and there is a hierarchy. In civil law countries, including Portugal, the hierarchy is by and large the following, starting from the most important to least important. Constitution, duly passed Act of Parliament, government emergency order, government decree, regional decree, city or town hall ordinance, and then the rest. Anything outside of this hierarchy, however, is to be ignored or taken as a guidance rather than legal norm, and this includes the regional health authority. Okay, so now on to the legal reasoning itself. So, the German tourists claim that 1. The diagnosis is incorrect and the tourist C, as noted in several legal papers, did not represent a danger to anyone and nobody presented solid evidence to the contrary, thus the ARS breached his personal liberty. 2. Quarantine based on such flimsy claims amounts to illegal detention in the legal sense. 3. RT-PCR testing is arbitrary given that there is no standard or equivalent regulation that is impartial and consistent. 4. The act used to decide to have them quarantined is of dubious legality and breaches the Portuguese constitution and subsequent jurisprudence, the Portuguese Administrative Code, the European Court of Human Rights jurisprudence, and relevant international treaties binding to the Portuguese Republic. Well, not only the judges agreed, but the judges in the Appeal Court of Lisbon went to great lengths to trash the whole narrative surrounding COVID-19 in Portugal. Needless to say, for a while, the media simply pretended that this rule never happened. Well, until they kinda had to. So, for starters, the judges trashed all of the quarantine orders issued outside of a state of emergency. Yes, not just the one case in the case of German tourists, but all of the previous and subsequent such orders by outlining clearly that the state in general, and least of all the regional health authority, have exactly zero power in deciding or enforcing such measures. Let me read from you from the court opinion, or motivation as it's called in civil law. Those of you who speak Portuguese will excuse me if I mistranslate something. I mean, I only learned enough Portuguese so I can laugh at Olavo de Carvalho's jokes. Anyway, so the judge says, quote, "Therefore, if the claimants are deprived of their liberty in the face of proven circumstances, it is necessary to trace the legal path in which we move, beginning the journey through the guiding light of the Portuguese legislative system, the Constitution of the Portuguese Republic. Thus, at the level of hierarchy of norms, it is necessary to remind ourselves that, according to Article 1 of the Constitution, quote, Portugal is a sovereign republic based on the dignity of the human person and on the popular will and committed to the construction of a free, just and supportive society, close quote. Hence, it is clear that the unity of legal meaning on which our system of fundamental rights is based on is human dignity. The principle of the dignity of the human person is the axiomatic reference of our entire system of fundamental rights. One of them, the most relevant in view of its structuring nature of the democratic state itself, is the principle of equality provided for in Article 13 of the Constitution, which states in its paragraph 1 that, quote, all citizens have the same social dignity and are equal in front of the law, close quote, adding in paragraph 2 that, quote, no one can be privileged, benefited, harmed, deprived of any right, or exempt from any duty due to ancestry, sex, race, language, territory of origin, religion, political or ideological beliefs, education, economic situation, social status, or sexual orientation, unquote. Since human freedom is not one-dimensional and can take on multiple dimensions, as exemplified in Article 37 and 41 of the Constitution, the freedom in question at Article 27 is physical freedom, understood as freedom of bodily movement, of coming and going, ambulatory or locomotion freedom, stipulated in paragraph 2 of this last article that, quote, no one can be totally or partially deprived of liberty unless as a result of a condemnatory judicial sentence for the practice of an act punishable by law with imprisonment, judicial application, or judicial application of another security measure. The exceptions to this principle are listed in paragraph 3, which provides that, quote, exception from this principle is the deprivation of liberty for the time and under the conditions determined by law in the following cases. A. Arrest in flagrante delicto. B. Detention or preventive detention for strong indications of a willful crime that corresponds to a prison sentence with a maximum limit of more than 3 years. C. Arrest, detention, or other coercive measure subject to judicial control of a person who has entered or remains illegally on the national territory or against whom extradition or expulsion proceedings are underway. D. Disciplinary imprisonment imposed on the military with guarantee of appeal to the competent court. E. Subjecting a minor to protection, assistance, or education measures in an appropriate establishment decreed by the competent judicial court. F. Detention by judicial decision due to disobedience to decision taken by a court or to ensure appearance before the competent judicial authority. G. Detention of suspects for the purpose of identification in cases and for the time strictly necessary. H. Internment of a patient with a mental anomaly in an appropriate therapeutic establishment decreed or confirmed by a competent judicial authority, unquote. Finally, we should remind ourselves, in the case of deprivation of liberty against the provisions of the Constitution and the law, the state is constituted with the duty to indemnify the injured party under the terms established by the law, as followed from paragraph 5 of Article 27, emphasizing, and especially in line with Article 3 of the Constitution of the Portuguese Republic, namely that the state is subordinate to the Constitution and is based on democratic legality. Paragraph 3, the validity of laws and other acts of the state, autonomous regions, local authorities, and any other public entities depends on their compliance with the Constitution. Having arrived here, having drawn up the legal territory, let us now take a closer look at the situation in which the Regional Health Authority moved in the situation under analysis in front of this court. Claimants SH, SWH, and NCO underwent a screening test for the SARS-CoV-2 virus, the result of which was negative for all, with the same test coming in positive for claimant AH, which led to the aforementioned order of prophylactic isolation and consequent permanence of these in the terms set out and proven. Therefore, in view of the content of the notification made to the claimants, this court cannot fail to express ab initio its perplexity at the determination of prophylactic isolation to the four claimants. As is clear from the definition given by the General Directorate of Health, quote, quarantine and isolation are measures of social isolation essential in public health. They are especially used in response to an epidemic and are intended to protect the population from transmission between people. The difference between quarantine and isolation stems from the state of illness of the person who has to be taken away. In other words, quarantine is used to people who are assumed to be healthy but who may have been in contact with an infected patient. Isolation is the measure used in sick people so that through social distance they do not infect other citizens. Turning to the present case, the Regional Health Authority decided to make a blank slate of essential concepts because they delimit differentiated treatment, the situations of infected people and those who are in contact with it, in the face of the order of prophylactic isolation to all claimants, although only one of them has positive results to the aforementioned screening test. And more decided to make a dead letter of the resolution of the Government Council number 207 of July 31st, forbidding the mandatory submission, the judicial validation of the competent court decreed to be a mandatory quarantine when it derives to the satiety of facts proven that the first three claimants at most are to be subject to mandatory quarantine. It did not do so within the 24 hours provided for in paragraph 6 of the aforementioned resolution, not even within a broader period, as in 48 hours provided for in Article 254, paragraph 1.a of the Criminal Procedure Code, or Article 26, paragraph 2 of the LSM, which is Lei da Saúde Mental, or the Mental Health Act. Continuing to make any communication and therefore the evident restriction of freedom of the first three claimants, this will always be illegal, says the court. In this step, the aforementioned Government Council Resolution number 207 of July 31st, 2020 provides at its point number 4 that in cases where the SARS-CoV-2 virus test result is positive, the local health within the scope of its competences will determine the procedures to be followed. The claimant AH positive in the screening test for the virus in question was notified and reiterated in the same terms as the other applicants of the order of prophylactic isolation between August the 10th and August the 22nd. At this point, it is necessary to make it clear that the notification made as proven under point 7 is brought from what is contained in the whatever regulation standard, a rule referred to it in addition to the normative circulars, which says that a contact classified as having high-risk exposure according to the terms of Annex 1 is subject to A. Active surveillance for 14 days from the date of the last exposure, B. Determination of prophylactic isolation at home or in another place defined at local level by the health authority until the end of the period of active surveillance according to the model of dispatch number whatever. Following this rule from the General Health Directorate, one reads, among others, in the normative circular that, quote, A. Close contacts of high risks are treated as suspected cases until the laboratory result test comes in from the suspected case. These close contacts should be screened for SARS-CoV-2. High-risk contacts are considered those who cohabitate with confirmed cases of COVID-19 and those who fall into the surveillance and control of nearby contacts measures. 3. Close contacts of high risk, given that currently it is estimated that the incubation period of the disease is between 1 and 14 days. They must comply with 14 prophylactic isolation days, even if they have negative screening tests during that period, and the test should be performed on the 14th day. If the 14th day test result is negative, they are discharged. If close contacts of high risk cohabit with the positive case, they should only be discharged when determining the curing of the positive case, and therefore the respective prophylactic isolation should be extended. 3. Compliance with prophylactic isolation. All persons identified as suspected cases until the negative results are known comply with prophylactic isolation. All people tested positive for COVID-19 and who are discharged after a cured test do not need to undergo a new isolation period. All passengers disembarking at airports in the region from airports located in areas considered to be zones of active community transmission or with active transmission chains of the SARS-CoV-2 virus must comply with the procedures in force in the region at the time. Arriving here, we analyze the legal value of norms and the guidelines of the General Directorate of Health and of the Normative Circular 39B of the Regional Directorate of Health. There is no doubt that we have entered the sphere of administrative guidance. Now here, notice the terminology. The judge calls them guidance. And then she goes on to illustrate. Quote, in this regard, with the specificity of reporting to the tax authority, which has the same administrative legal position as the National Health Authority, the so-called administrative guidelines, traditionally presented in the most diverse forms, such as instructions, circulars, circular letters, normative orders, regulations, opinions, etc., which are very frequent in tax law, constitute internal regulations that, as they have only the tax administration as their recipient, only the latter owes them obedience, being therefore mandatory only for the bodies located hierarchically below the agency that authored them. That is why they are not binding on individuals or on courts. And this is whether they are organizational regulations which define rules applicable to the internal functioning of the tax administration, creating working methods or modes of action, or whether they are interpretative regulations which proceed to the interpretation of legal or regulatory precepts. It is true that they densify, make explicit, or develop the legal precepts previously defining the content of the acts to be performed by the administration when they are applied, but that does not make them the standard of validity for the acts they support. In fact, the assessment of the legality of the acts of the tax administration must be carried out through direct confrontation with the corresponding legal norm and not with its internal regulation, which interposed between the norm and the act. Now, the problem of the normative relevance of the circulars for the tax administration was already raised and considered in the Constitutional Court judgments, and the court decided, which we agree, that the prescriptions contained in the circulars of the tax administration, regardless of their persuasive irradiation in the practice of citizens, do not constitute norms for the purposes of the constitutionality control system committed to and by the Constitutional Court. As underlined in that note, these acts in which the circulars are prominent emanate from the power of self-organization and the hierarchical power of the administration. They contain generic service orders, and it is for this reason and only within the respective subjective scope of the hierarchical relationship that they are guaranteed compliance. They incorporate guidelines for future actions transmitted in writing to all subordinates of the administrative authority that issued them. These are standardized decision modes assumed to rationalize and simplify the operation of services. This is worth saying that although they can indirectly protect legal certainty and ensure legal treatment through uniform application of the law, they do not matter when they deal with in relation to individuals, nor do they constitute a decision rule for the courts. Consequently, lacking a heteronomous binding force for individuals and imposing themselves on the judge only because of the doctrinal value that they may have, the prescriptions contained in these circulars are not standards for the purposes of the constitutionality control system within the jurisdiction of the Constitutional Court. With that said, allow us to conclude that the administrative guidelines conveyed in the form of normative circulars, as is in the present case, do not constitute provisions of legislative value that can be the subject of declaration of formal unconstitutionality, unquote. Now, this is a little bit long, a lot of legalese, but in plain English, the judge explains that the norms and circulars and other papers of an authority, be it the tax authority or the health authority, cannot, in and of themselves, create law, nor can they be binding to anyone not explicitly and contractually located beneath them inside of their institution. So just because the tax authority tells its employees to wear blue, for instance, that doesn't mean you, the regular citizen, should also wear blue. Not even when interacting with the tax authority, because the rule does not apply to you. It only applies to those who work for the tax authority, or otherwise known as contractually located beneath them hierarchically. The judge makes the legal case that from a normative hierarchy perspective, which is one fundamental principle of the Portuguese law, the circulars of the health authority that require quarantine are of the same legal value with the circulars of the tax authority, and thus inferior in the hierarchy to be able to impose such grave measures as deprivation of liberty. Judge Anna Paramesh then goes on to explain in great detail, and even though this will also make the video much longer, trust me, it's worth it. So she goes on and says, quote, "And to make it clear that the norms invoked by the regional health authority that supported the deprivation of liberty imposed on the claimants through notification of prophylactic isolation are non-binding administrative guidelines for claimants, just look at what they at who they are addressed to specifically." And she quotes straight from the document: "Normative circular number whatever for health units of the regional health service, municipal health delegates, Ashoesh Regional Civil Protection and Fire Service, Linde Saúde Açores, subject screening for SARS-CoV-2 and addressing suspected or confirmed cases of SARS-CoV-2 infection. Source, Regional Directorate of Health, number 15 from 2020. Subject, COVID-19 contact screening. Keywords, COVID-19, SARS-CoV-2, contact screening, epidemiological research for the health system," unquote. In this sentence and in summary form, this court cannot fail to underline that the present case, we allow ourselves to say that this represents an aberrant deprivation of liberty of persons, and it absolutely lacks any legal basis. We urge the plaintiffs not to come up again with the argument that the defense of public health is at stake, because this court will always act in the same way, that is, in accordance with the law. Speaking of the law, nobody has yet to show any judicial confirmation enshrined in the mental health law for cases of compulsory internment, which is the only way which such measures can sometimes be legal, unquote. I mean, this is glorious. Basically, the judge tells the health authority to fuck off with its whining about this so-called public health. Or in more polite terms, the court applied principle number 4, namely that unless there is a state of emergency, the opinion of any specialist is inherently inferior to the basic freedoms of individuals. Then the court goes on to list other procedural violations, such as the claimants never having been presented information that they could understand, either written in German or presented to them via an interpreter, which in itself represents a violation of Article 5 and Article 6 of the European Convention of Human Rights, which is binding and mandatory legislation in Portugal for everyone all the time, even when you're afraid you might cough. The judge is very courageous, and she also goes on to cite Gianluigi Gratta of Università degli Studi di Milano Statale. The court says, quoting Professor Gratta, "Right now the country's energies are focused on emergency, but the need to protect fundamental rights also, and above all in an emergency, the courts are required to do their part, because in addition to medicine and science, law, and human rights law in the first place, must be at the forefront, not to prohibit and sanction, as is being emphasized too much today, but to guarantee and protect the liberties of everyone. Today the emergency is called a coronavirus. We don't know what emergency may hit tomorrow, and what we do or don't do today to maintain compliance with the fundamental principles of the system can condition our future," unquote. Now, this signals that the Appeals Court of Lisbon is aware of the European and global implications of its rulings. Using this rationale by Professor Gatta, who again is from Italy, so already signaling that legal experts have been working transnationally on this madness, the court then goes on to even more controversial territory in a very courageous fashion. So the court, for instance, dismisses the RT-PCR summarily by invoking the first 3 principles: in dubio pro reo, all that is not explicitly regulated does not exist, and all that is not done duly in accordance with procedure is ipso facto disqualified. Of course, the court doesn't put it in these simple terms, but it doesn't spend too much time with the whining by these so-called experts here. Let me read it to you because it's really, really glorious where it is here. Quote, The request made by the health authority to maintain the measure would also be manifestly unfounded because a. the prescription and diagnosis are medical acts under the exclusive responsibility of a doctor enrolled in the order of doctors. Thus, the prescription of auxiliary diagnostic methods, as is the case of tests for the detection of this particular viral infection, as well as the diagnosis of the existence of a disease in relation to each and every person, is a matter that cannot be performed by law, resolution, decree, regulation, or any other normative way, as these are acts that our legal system reserves to the exclusive competence of a doctor, being sure that in advising his patient he should always try to obtain his informed consent as per paragraph 1 of Article 6 of the Universal Declaration on Bioethics and Human Rights. Translation: mandatory testing is illegal. The results should be interpreted only by a doctor, and there must be a doctor present at all times to agree that the person is ill. The test itself is not enough, and the court doesn't care if you believe otherwise. She goes on. B. In the case that concerns us now, there is no indication or proof that such diagnosis was actually carried out by a professional qualified under the law and who had acted in accordance with good medical practices. In fact, what follows from the facts taken for granted is that none of the applicants was even seen by a doctor, which is frankly inexplicable given the alleged seriousness of the infection. C. The only element that appears in the proven facts in this respect is the performance of an RT-PCR test, one of which presented a positive result in relation to one of the applicants. D. In view of the current scientific evidence, this test is in itself unable to determine beyond reasonable doubt that such positivity corresponds in fact to the infection of a person by the SARS-CoV-2 virus for several reasons, of which we highlight two, to which the issue of gold standard is added, which due to its specificity we will not even bother to address. Reason number 1, the test's reliability depends on the number of cycles that make up the test. And reason number 2, the test's reliability depends on the amount of viral load present. Translation: there is no standardization of the number of cycles, which means the exact same person tested in the same hour but on different number of cycles run in a test can be both positive and negative to the Wuhan coronavirus, which from a legal perspective it is absolutely haram and straight up garbage as an evidentiary standard, which is why the judges just laugh the so-called experts out of the courtroom when they claim that the RT-PCR is the so-called gold standard. Well, no, it's not. It may be the gold standard in the propagandistic la-la land of the sanitary fascist regime that these clowns want to build, but from a legal and, yes, scientific perspective, the way RT-PCR tests are being processed in Portugal and between you and me almost everywhere on the planet is an absolute joke and should be regarded as such. And the Portuguese court makes no qualms about how little it cares about what your precious BS tests say. Quote, 3. Any diagnosis of any act or any act of health surveillance, as is the case of determining the existence of viral infection and high risk of exposure, which are included in these concepts, performed without prior medical observation of the patients and without the intervention of a physician enrolled in the order of medics who proceed to assess their signs and symptoms, as well as the tests that they deemed appropriate for their condition, violates regulation number 698 per 2019, as well as the provisions of the Article 97 of the Statute of the Ordem dos Médicos, or the Order of Medics, thus being criminally liable for the crime of usurpation of functions as per the Portuguese Criminal Code. 4. Any person or entity that issues an order the current of which leads to deprivation of physical or ambulatory freedom of others, whatever the nomenclature this order assumes, confinement, isolation, quarantine, prophylactic protection, health surveillance, etc., etc., if it does not fit the legal provisions, namely in the provisions of the Article 27 of the Constitution, that person or entity will be engaging in imposing an illegal detention because it is ordered by an incompetent entity and because it is motivated by a fact for which the law does not allow the imposition of such measures, unquote. Ouch! No wonder the media never talked about this ruling. In multiple ways, it sounded like me in the Romanian language podcasts or during private consultations. The judges were based and red-pilled for sure. Now, while all of this is fun, one should remember that this ruling is only binding to Portugal and only outside of a state of emergency. So the first effect of it was for Portugal to reintroduce state of emergency. However, that does not necessarily mean that such measures suddenly become legal. It just means that the threshold to have them thrown out in court is slightly higher. So, for instance, the argument of fundamental liberty is much weaker when a state of emergency is declared, but the argument about the inherent garbage that RT-PCR tests are is still valid. So that one can and should be used again, and it would likely stand. However, this legal reasoning and this ruling has already created new jurisprudence and fundamentally transformed practices for the better, not just in Portugal, but all over Europe and around the world, as a matter of fact. Why? Because most countries in the world run on civil law. Even most of the countries nominally on some variant of English common law are in fact running on a mixture between the two, Roman law occupying an increasingly higher share, especially in administrative courts, which is relevant because most of the COVID-19 so-called measures are in fact administrative rather than military, that will be subjected to military law, or criminal, subjected to trials by jury in the Anglosphere, or prosecutorial conduct in Roman law countries. That's why this ruling was already quite transformative. But it can do even more if you decide to try your luck in court. Okay, let me give you some examples. On December the 24th, a Dutch citizen sued the Dutch government over the obligation to conduct an RT-PCR test before being allowed to legally get back into his own country upon returning from Tanzania. Remember, Tanzania is the country whose president openly rejected the RT-PCR test after having tested various fruits, a sheep and a goat, for coronavirus. They all came back positive. The Tanzanian president has a legit scientific background as a mathematician, I think. Needless to say, an RT-PCR test is hard to come by in Tanzania after it turned out that these tests are so accurate that they come out positive at a pow-pow sample. So, this Dutch citizen used this aspect and the rationale from the Lisbon Court of Appeal to contest the measure of mandatory testing in the Netherlands. He also asked for expediency as his flight was due on January the 3rd, just 9 days after he filed his lawsuit. And, lo and behold, Rechtbank Den Haag, or the Hague Court, ruled on December the 31st that the state has no legal basis to impose mandatory testing, least of all with an RT-PCR test. Although this ruling merely offered an injunction for this individual in particular, the ruling is not just binding but definitive, which means it can be taken up back to the courts and litigated all the way up to the Supreme Court, and as far as I know, several Dutch lawyers are already working on this. Now let me read you from the motivation of the Hague Court. Where is it? Here. Quote, "The cooperation required from Dutch airports and for the purpose of instructing airlines to require proof of a negative PCR test is, according to the state, based on the provisions of Articles 53 and 54 of Wet Publieke Gezondheid, or the Public Health Act. In the opinion of the preliminary relief judge, however, these provisions, read either separately or in conjunction with each other, do not provide any basis for the power to order the operator of an airport to have measures taken that need to be implemented in another country, in this case the country of departure of an aircraft that will land in the Netherlands. And if this provision should be interpreted much more broadly, the question is whether the requested cooperation may go as far as to allow travelers, such as the claimant, are essentially forced to submit to an examination, in this case a PCR test, otherwise they will not be admitted to their return flight. For an obligation that through this stepped series of measures, namely an instruction from the minister, an order from the chairman of the security region, and an order to an airline by the airport operator, is ultimately addressed to a traveler flying to the Netherlands. Like the claimant also argued, Articles 53 and 54 of the Public Health Act, in the opinion of the preliminary relief judge, clearly have no basis. An explanatory memorandum shows that Article 54 of the Public Health Act does not create any ground for an obligation to cooperate with an investigation by a traveler. After all, this includes the following: the cooperation of the traveler in such an investigation cannot be enforced directly. However, the mayor may decide to subject travelers to quarantine measures on the basis of Article 35 if the applicable conditions have been met. The conclusion must therefore already be that the claimant is right to complain about being forced against their will to have a PCR test. Such an obligation, which applies to a Dutch subject who wishes to return home, requires a sound legal basis, and this is not enshrined in Articles 53 or 54 of the Public Health Act. That there is an urgent need to prevent the further spread of the virus in the Netherlands, also by possibly infected passengers flying to the Netherlands, is not under discussion as far as the preliminary relief judge is concerned. But for a radical obligation such as this one, which concerns the physical integrity of a passenger, at the very least a concrete legal basis is required. The fact that the test contains only a minor restriction on the right of inviolability of the body, and that the administration of the test is easily done and very little stressful, cannot detract from this obligation placed upon the state." Close quote. Translation: your procedure is wrong, your rationale is wrong, and the claimant is correct in claiming his right to outright refuse RT-PCR testing for any reason or no reason. Ouch. The rationale used is virtually identical to the one used in Portugal, basically. Here's another example. On January the 20th, the World Health Organization, or as we call it here on the sofa, the Wuhan Honk Organization, suddenly became a conspiracy theorist. Up until this ruling from the Portuguese court, any public questioning about the accuracy of RT-PCR tests, any suggestion that maybe, just maybe, a so-called positive result does not automatically mean that a person is ill, nor does it automatically mean that a person is contagious and therefore a danger to others, no matter how small that danger may be, and that the approach of taking any test, anywhere, on any laboratory, on any person, anytime, simply at face value, is not science. It's exactly the opposite of science, because the input data is fundamentally flawed right from the get-go. All of this was conspiracy theory in most countries of Europe. Then came the criminal investigation against the Wuhan Honk Organization in Italy, and this ruling in Portugal, and the ruling in the Netherlands. Now suddenly the unreliability of the RT-PCR test is no longer a conspiracy theory, but official guideline of the World Health Organization. So, the China Health Organization writes on January the 20th, quote, WHO guidance diagnostic testing for SARS-CoV-2 states that careful interpretation of weak positive results is needed. The cycle threshold needed to detect virus is inversely proportional to the patient's viral load. Where test results do not correspond with the clinical presentation, a new specimen should be taken and retested using the same or different NAT technology. WHO reminds users that disease prevalence alters the predictive value of test results. As disease prevalence decreases, the risk of false positives increases. This means that the probability that a person who has a positive result, SARS-CoV-2 detected, is truly infected with SARS-CoV-2 decreases as prevalence decreases, irrespective of the claimed specificity. Most PCR assays are indicated as an aid for diagnosis, therefore healthcare providers must consider any result in combination with timing of sampling, specimen type, assay specifics, clinical observations, patient history, confirmed status of any contacts, and epidemiological information, close quote. Uh-oh. Uh-oh. I mean, I personally was called all sorts of names for saying exactly this 8 months ago. Ouch. Now, how did I know? Well, unlike these so-called experts, I do not adhere to the dogma of scientism. Just because someone wears a white coat and says something unbelievably stupid in public, that doesn't mean that that something stops being unbelievably stupid just because it's been said by a so-called expert. And the idea that a positive result of an RT-PCR test makes one ill and contagious is, fundamentally speaking, grotesquely stupid. Something so insane that only idiots would take at face value. Now, unfortunately, the planet is full of idiots. I'm not trying to be funny necessarily when I insist that the fundamental rule of humanity is people are not stupid, people are bloody stupid. And this applies even more so to government officials, health experts, bureaucrats, and other marginal life forms whose existence should be questioned all the time, and anything they say should be presumed wrong until proven otherwise. Anyway, so suddenly the World Health Organization is a conspiracy theorist. So is the Court of Hague. Who else became a conspiracy theorist? Well, the British Journal of Medicine. The prestigious journal, through the voice of Peter Roderick, Principal Research Associate at the Faculty of Medical Sciences of Newcastle University, suddenly asked, is it really lawful to require self-isolation after a positive COVID-19 test? And even a layman like him, in terms of law, using his very expert knowledge in medicine, had to conclude that the answer, when it comes to the United Kingdom's treatment of adult students in campuses, is a resounding no. That is to say, 0% of the measures taken on campuses at the behest of the Johnson cabinet in terms of testing and isolation are lawful. Uh-oh. Back in May 2020, I asserted that all of the measures related to the general public in the context of the Wuhan virus are concurrently useless, immoral, illiberal, and illegal. I stand by what I said then, and I insist that it is true today, and as it was true in May 2020. And the more time passes, the more the courts sound like me, rather than the paid shills, useful idiots, and the middle-class left-wing pricks in the cathedral media. Now, why does this happen? Well, it happens because the law is what it is. It's not living, and it has a way of functioning all the time, regardless of whether you're afraid of a cough or of Ebola. There is no exception to the rule of law for cases when government bureaucrats, like some sanitary fascism here and there, or a bunch of loonies decide they're now hypochondriacs. And no, saving grandma is not a good enough excuse to suspend the rule of law and surrender extraordinary powers to enact extremist dictatorial measures to unaccountable bureaucrats. And no, you can't do that even if 99% of the populace agrees with you. And here's another effect. Slowly, but absolutely consistently, the approval rating of the measures has been flattening. If anything, it's probably the only curve that's been flattening over the last 10 months. The Netherlands has violence on the streets because of the measures. Tens of thousands of people are marching routinely on the streets of Vienna and simply refuse to observe any of the disdainful nonsense peddled by idiots and pretending that has anything to do with public health or science. In Czechia, people organized as a political movement, and they will topple the government sometime this year, for sure. In Italy, the government already resigned, at least in part because of the pandemic measures, as more and more Italians wake up to the fact that, for the most part, the economic and social destruction foisted upon them was entirely for nothing, and illegal on top of that. By the way, Italy did everything Anthony Fauci recommended. Everything. To the T. Florida, in the United States, did mostly the opposite. Now, if you're a 75-year-old, you are now safer in Florida or Sweden than you are in Italy, at least as far as the Chinese virus is concerned. But all of this is still in its infancy. You, yes, you watching this, can and should do more. At least in Europe, opening a lawsuit against the measures costs between $2 and $50, rarely more than that. And usually, if you win, you even get that money back as well. Anyone affected by these measures has legal standing, or procedural quality as it's sometimes called in Roman law. For instance, I sought to get fined for not wearing the muzzle, and even though I tried really hard, every time I exposed my legal case to a police officer, they somehow refused to issue a fine. Gee, I wonder why. However, others that I have advised were more successful in getting a fine. Then we helped them go to court. Just in the month of January alone, we got a definitive verdict on 5 lawsuits just in Romania, all 5 favorable, all 5 on the pandemic measures. We further got 3 preliminary verdicts, that is to say there will be an appeal. 2 are favorable, 1 is unfavorable, and that's just January and a small group like the Freedom Alternative Network in just one country. It doesn't cost much, and the effects of losing are marginal, yet the effects of winning are groundbreaking, because as Gianluigi Gatta said, what we do or don't do today to maintain compliance with the fundamental principles of the system can condition our future. It's not just about the Wuhan flu, it's about creating freedom-friendly jurisprudence and upholding previously existent freedom-friendly jurisprudence. And you should be creative. Just a few days ago, someone sent me to look at a lawsuit by someone completely unrelated to our group. Someone was suing a university for increasing its tuition fee without any justification. He argues that, on the contrary, given that the university has had lower expenses due to students allegedly studying online, the tuition fees should be temporarily lowered and surely, at the very least, can remain unchanged. It's an interesting argument from a legal perspective. I can hardly wait for that lawsuit to proceed through the court system, because if he wins, then the state-sponsored universities will necessarily have to join our side. Suddenly, they will have a direct financial interest in flattening the panicdemic insanity, because that's exactly what it is. Insanity-driven panic at a societal scale, or a panicdemic. None of this has anything to do with science, and claiming otherwise means engaging in being monumentally stupid in public. And, as the Bible or the Torah should say, thou shalt not be stupid in public. Also, keep in mind, lower enforcement may seem like a good gain, and it is on the short run, but much more efficiently is not to flatten the enforcement of the measures, but to flatten the measures altogether in court. It works. Recently, the Romanian government was being pressed by all sorts of shills who make a lot of money out of the measures, as well as useful idiots, never a shortage of those, to keep some restrictions in place. And the government might have been inclined to agree, but they also don't like it when they're being flattened in court. So their official messaging was, well, we risk being sued into oblivion if we don't lift the restrictions, so stay safe. That is what the courts can do. But the courts can only do this if the citizenry not only knows its rights, but is willing to defend them in court as well as in the streets during the protests. Both are absolutely necessary. Oh, and political organizing helps as well, like the Czechs and the Poles did. Yeah, I know. Freedom isn't free. Tough luck. Remember that entropy is on the side of darkness. Light is on our side. We have to spread light every time. When we stop spreading light, darkness wins. Always. No exceptions. Sorry. So, yeah. That's really all I had to say. Of course, links and further reading material is available in the low bar if you want to consult the legal documents. Some summary in English. Unfortunately, not much is available in English, though I don't see that necessarily as a bad thing. Anyway, that's it for now. Don't forget to subscribe, visit our website, consider giving a shekel if you like what we do, and I will see you all soon on the Freedom Alternative.